Thank you for joining us for today's webinar titled RAK ICC, a gateway for structuring to the wider region. My name is Lara Malab and I'm the Director of Business Development and Marketing at RAK ICC. We are very delighted to welcome our panel of speakers from King & Spalding, a leading law firm with 22 offices across the globe, including offices in the GCC, and Crowley, who are ranked the 8th largest accountancy network in the world, with around 800 offices in more than 130 countries. Crowley are also our registered agent. In this webinar, we will cover some of the key highlights and solutions available at RAK ICC. We will also talk about the Middle East opportunities and a case study on holding structures. Just a little housekeeping before we get started. This webinar is being recorded and shall be shared with you later and will be posted on our website for those who were unable to attend it. If you have any questions during the presentation, please type them into the question box in your Zoom control panel. I'll bring them up during the Q&A session at the end, and in case we were running out of time, we will be responding to your questions individually following the webinar. Now, our speakers for today: Dr. Samir Al-Ansari, CEO of RAK ICC. Dr. Samir is a UK qualified chartered accountant with over 30 years of senior corporate operational, private equity investing, board and strategic advisory experience. Prior to joining RAK ICC as CEO in April 2018, Dr. Samir, and just to name a few, was the Vice Chairman and CEO of the industrial group KSA, the CEO of RAK Capital, and has also helped establish Dubai Holding in 2004 and founded Dubai International Capital. Dr. Samir will give us a brief introduction to RAK ICC, provide us with some of the key RAK ICC updates, and present us the various RAK ICC solutions. We have also Nabil Issa, is a partner in the corporate finance and investments group of King & Spalding, working from the Dubai and affiliated Riyadh offices. Mr. Issa's experience include work in the areas of Sharia compliant funds, joint ventures, foreign investment, private equity, venture capital, and real estate industry transactions. He's particularly known of his development and innovative fund and investment structures for real estate and private equity venture capital investments in Saudi Arabia and the UAE. Nabil is also joined by his colleague Dora Chan, who's an associate with King & Spalding based in the Dubai office. She focuses on the formation and structuring of a variety of investment funds, including private equity, real estate and infrastructure, venture capital, fixed income, trade finance and equities funds. She has acted in relation to the structuring of asset management groups and the establishment of carried interest plans for asset managers. Nabil and Dora will present the various issues with traditional corporate vehicles in the Gulf, the solutions and the benefits of using a RAK ICC structure. We also have Atiq Munshi, a qualified chartered accountant, a certified fraud examiner and certified internal controls auditor, and has an experience of over 25 years in the field of audit, business advisory, risk and compliance. Atiq is specialized in areas of mergers and acquisitions, forensic accounting, new business setup expansion, diversification advice, formation of offshore and onshore companies in the UAE. Atiq will also share his experience using RAK ICC structures for investments in the region and provide us with a case study on this matter. Now, without further ado, we will turn the time over to Dr. Samir.
Thank you, Lara. Good morning, everyone. First, let me start by thanking Nabil, Dora, and Atiq for taking the time to join us today and to be part of the webinar. As many of you know who've joined us on several webinars in the last few months, we have frankly taken advantage of people being more available, working from home and so on, to really get to know RAK ICC. And one of the key subjects that has often come up is the use of RAK ICC structures in the region, how appropriate and useful are they, and so on. And so we felt it was timely that we have some of our key partners join us in a webinar to address some of those opportunities. RAK ICC continues to go from strength to strength. We've had a fantastic year despite all of the challenges. I think we're all lucky to be part of the UAE, which is, as we all know, a great jurisdiction to be operating from, that offers various solutions and various opportunities, and meets all the requirements that a modern, vibrant, and well-regulated society requires. And there is clearly an undeniable shift towards a more reputable jurisdictions, where there is more and more pressure on adhering to global standards of regulations, compliance, and so on. The economic substance requirements that were rolled out this year is a key example of that. And we're finding that the pure offshore jurisdictions are increasingly being placed on blacklists or watch lists with serious reputational and operational consequences for those clients. And more of those jurisdictions, clients, corporate service providers, law firms, and so on, are looking for alternative solutions. Next slide, please. I'm delighted to say that actually at RAK ICC, we had a tremendous year despite all the challenges that we're all aware of, that we have faced and continue to face in 2020. And I think that is a big reflection of the positioning of the UAE, the great work that the team at RAK ICC has done, and the fact that we are gaining reputation for being a highly compliant and highly efficient registry. In fact, not so long ago, we received an award for excellence in international business registry 2020. More importantly, we have received recognition by the FATF team for the good governance practices at RAK ICC. In 2020, we launched RAK ICC Foundations, which has proved to be extremely popular with practitioners from within the UAE and outside, and is, I would say now, a big competitor to the foundations regimes of the ADGM and the DIFC. In 2020, because of all the challenges, we've also made every effort possible to provide business stimulus initiatives to help clients and agents through these challenging times. Recently, we've partnered with Regis Business Center to offer discounts for RAK ICC clients, and many other initiatives and discounts and support packages that we've provided throughout 2020. And with that, I can tell you that 2020 is proving to be an even more successful year for us than 2019, despite all the challenges. Very often we're asked, how do we compare to jurisdictions? And I wanted to highlight just 2 or 3 things before we go into the key features. That very often people don't recognize or realize that common law regulations are applied to RAK ICC companies. We have MOUs with the DIFC and ADGM, allowing RAK ICC clients to make use of the DIFC and ADGM courts. We also have an MOU with the Dubai Land Department that enables RAK ICC companies to hold real estate in Dubai. And we are licensed by the DIFC courts to register DIFC wills through the RAK ICC. So these features provide an additional layer of comfort for many users of RAK ICC structures who are often reluctant or unfamiliar with the laws of the UAE and the application of courts, whether it's Dubai courts, Abu Dhabi courts, Ras Al Khaimah courts, and so on. So why RAK ICC? And again, I won't go through all these in detail because the features are pretty common in most jurisdictions. And if you read through them quickly, you'll see that they are very similar. However, I would like to highlight a few differences. We've recently conducted a survey with existing clients and people who we would like for them to be clients. And the one thing that came up very strongly in every answer with our clients is the ease of doing business, the access to the RAK ICC team, the clarity of the regulations, and the help and assistance that the team provides. At the end of the day, this is a people business. We don't make phones and sell them. So we pride ourselves on the fact that people find it easy and convenient to do business with RAK ICC. But if you add to that some features that are in addition to what you would find in other jurisdictions, for example, we have different classes of shares and the ability to register a share pledge. I think when you look at the structures that are being discussed later, you will see that is important. That does create an important differentiator. It's a key feature that lawyers and clients are often looking for in structuring their corporates. So we've tried to, over the years, identify gaps and fill those gaps. And I think some of them will become more obvious as we go through the presentation. But generally, the features are very similar in most jurisdictions and in the simplest of the IBC structures that you would be familiar with. When you talk about products and services, again, you know, an international business company is a plain vanilla type of structure, but it's how you use the structure that counts and what special features you can add to it that make the difference. We've also added over the years things like the segregated portfolio companies, which when we talk about the structures later, you will see are very popular, are required, can provide features that are very useful to some structures. Also more common these days are corporate special purpose vehicles or special corporate vehicles, SPVs, which are becoming very, very popular as they provide segregation and ring fencing in special structures. We've talked about foundations, we've talked about wills, and we will talk about the foundation structures and uses in a little more detail in the rest of our webinar. ESR solutions. So you know, we jumped the gun because we knew this was coming, and we started looking at structures and solutions for economic substance regulations and requirements. And all of you would know that this year has been a very heavy year on economic substance requirements, solutions, implementation, and the rules and continue to change, and we continue to get surprises. But I think we're all going in the same direction, in the right direction. There are many solutions in RAK ICC, and one of the products that we introduced very early on, in fact last year, is what we call the premium product, which is a RAK ICC holding company with a RAKIS, which is our sister company, the RAK Economic Zone subsidiary. And so that gives you a holding company and an OpCo. The OpCo provides the offices, the employees, and so on, and therefore ticks the boxes from an economic substance requirements, and then provides you with many features and advantages and flexibility in how you structure a group going forward. We also offer conversion from a RAK ICC entity to RAKIS, therefore to be able to become a free zone entity and meet the economic substance requirements. We've also created branch solutions whereby you create a branch of the RAK ICC company, and through the branch, which is the same legal entity, be able to meet the economic substance requirements. Of course, you can create subsidiaries elsewhere, which can then be used as the OpCo, and that provides the economic substance. And our sister company RAKIS recently launched what they call the RAKIS Global product, which is a mid-shore offering that again helps you meet economic substance requirements. All of these solutions, I would say, are helping RAK ICC to move away from having pure offshore structures to having more mid-shore structures as the rules and regulations and requirements change over time. So a couple of more slides before I hand over to Nabil. Very often, RAK ICC companies are used for either international business purposes or private wealth purposes. At the core of this is tax planning and wealth management, succession planning, inheritance planning, and so on. But these features and these uses are what we find in our 15,000+ companies. Private wealth, tax planning, taking advantage, whether it's from a personal perspective or from a corporate perspective, of the over 100 double taxation treaties that the UAE has, and creating structures that allow you, for example, through the premium product and through having subsidiaries in the UAE, to apply for a tax certificate to efficiently structure your businesses, or to use that as a gateway into the region to also achieve efficient tax planning, is extremely popular and is growing in popularity. And we find that more and more of the users are now thinking closer to home, one, for economic substance requirements, but secondly, because of the strong reputation and the fact that the UAE is a whitelisted jurisdiction. Instead of using pure offshore structures in pure offshore centers. So whether they go to Mauritius or they go to BVI or they go to Cayman, which was on a blacklist, now taken off the blacklist, and so on and so forth, we find more and more clients are shying away from that and deciding to use UAE structures, and very often RAK ICC structures, to achieve their objectives. I'm going to touch very briefly on the passive holding structure and leave the rest of the structures to my colleagues. But this is probably one of our most popular uses of RAK ICC companies, where a parent company or an investor creates a RAK ICC holdco under which they have their investments, their equities, their real estate assets, and so on. And of course, the main benefit of a passive holding company like this is the ease of transfer of ownership in the future. Of course, maintaining some privacy over the ownership of the various structures. And once you have a structure like this, you have the ability to get financing against the assets and so on and so forth. So we find this to be a very, very popular structure, and is probably one of the drivers of growth of RAK ICC. The next few slides I am going to skip. So there are several active holding company structures and examples, but in the interest of time, I will skip those and hand over to Nabil. So structured solutions, foundations, we will also cover later after Nabil's presentation. With that, I'm going to hand over to Nabil.
Thank you, Dr. Samir and Laura. So we thought, we were first discuss at a high level, what are the regional opportunities and why are we excited about the developments at RAK ICC and why it may be useful. So first of all, we're seeing a number of mega projects in the region, particularly in Saudi Arabia. It seems like hardly a week goes by without announcing not a new project, but a new city. The Red Sea project, NEOM, etc., creating projects that are, not project size, but giga projects, as they call them. And they have all sorts of components, where there's going to be entertainment areas, healthcare, water, infrastructure, and so forth. Again, the theme you'll end up seeing on as we discuss the various structures is, as clients look at the region, they're very excited about the opportunities in the region, but they say, hey, look, we're not comfortable with the local law risk. And we'll go in that. Excuse me. We're seeing also a number of privatizations in the region, whether the UAE, Kuwait, and Saudi, everything from grain silos, water, roads, power, etc. Technology. So this is one of the biggest areas we're seeing, is that a huge mushrooming of groups who are setting up venture capital funds and entities tapping into that. We're blessed in the region to have an unusually young population. many of whom have studied all over the world, have come back to the region, or from elsewhere in the region who decided to make the UAE home and starting brand new companies. But again, the frustration has been for them is that, look, myself, Dr. Samir, and Laura want to start a company, but we say, if we want to copy Silicon Valley model, we can't have class A, class B. How do we regulate this? This is not going to work. And a lot of startups fizzled out because they didn't have that model until now or until quite recently. And the last one is somewhat related, are these joint venture opportunities, whether again, it's to do manufacturing in the region because there's a cost benefit or otherwise. We can go to the next slide. So, hey, that sounds all great. There are lots of opportunities in the Gulf. You're telling us about giga projects, joint ventures, all sorts of things happening in Kuwait, Saudi, UAE, and elsewhere. Why should I care? And why should RAK ICC make any difference? We have to also be a bit honest with ourselves in the region. While we're very excited about the opportunities, the legal developments are improving every day in the neighboring countries and even onshore UAE, but they are not at the level that gets a lot of investors very comfortable. So for example, a limited liability company, you and I enter into an LLC, whether we're talking about Kuwait, Saudi, or the UAE. I want to sell my shares. You can stop me. I have to show up before a notary public. I have to bring a resolution of power of attorney. I have an 80-page shareholders agreement, but I have a 5-page articles of association for an LLC, which doesn't reflect the real deal between us. Again, the same themes, difficulty admitting new investors. We can't have investors coming in and out, which is a disaster for venture capital and growing companies. Again, a very common to have drags, tags, capital calls, dilution. I enter into an arrangement with 5 of my closest friends. But we say, hey, look, if we're going to need more money in the company, you're going to get diluted. Everyone says yes. A situation happens a year later. My best friend says, I don't have it. I can't dilute them. And unfortunately, just causes a lot of tension between partners who start out as good partners but end up in disaster. Dr. Samir mentioned the importance of different classes of shares. Typical feature elsewhere, but again, almost non-existent in the region. Sometimes it's in the company's law of some of the countries in the region, but in reality, you can't get it reflected in the registered bylaws for article association. Some of the jurisdictions have local partner rules, and ABC country or XYZ country, a UA national needs to hold, for example, 51% of the shares. But let's just say, an example that we've done before in RAK and elsewhere is that the 51% Emirati partner says, look, I'm going to contribute 18% of the capital, not 51% of the capital. We need to get a structure where they're going to contribute a certain amount of money. We're going to meet the onshore rules, but at a different level, we're going to have, let's say, the agreement reflecting that partner is going to get 18% of the profits. And then as the business grows and as they perhaps introduce us to opportunities, they will also have, the option to grow their percentage in-kind shares, in addition to cash, things that we normally can't do in a standard onshore LLC. Sometimes you require the management to be national of that company or on the ground. The extensive time it takes to form companies in Kuwait, Saudi, and elsewhere, and just the cost of setting up so many entities and coming up with very intricate ways of trying to enforce our tag, drag, and dilution. I spent time at 7 a.m. this morning with the U.S. client, as they were insisting to have a Saudi LLC with their partner. And at the end of, got off the call half an hour ago, said, why are you doing this? You can set up an entity in RAK. We can have it under English law. We just need to convince the partner because we're wasting a lot of time and money trying to create fictitious workarounds when there's real solutions that exist in the region. Maybe we can jump to the next slide. So I'll just start briefly and I'll turn to my colleague Dora. So again, the reason that we get very excited about RAK as a solution is that we can choose in our contract. So again, in my challenge this morning at 7 a.m. with this US client is that, look, we're trying to reflect provisions in an agreement that don't work under local law. If we simply set up our joint venture entity in RAK ICC, we can reflect the ownership percentages. We can have different classes of shares. We can reflect tag, drag, and dilution. We can have enforceable put options and build it under English law and have our disputes heard by the appropriate tribunal in ADGM and DIFC with common law judges. With that, let me turn to Dora to provide some more light on that.
Sure, and the key points I want to make before we move to the slide and talk about RAK ICC. This is not just theoretical. Every year, our law firm deals with litigation or deals with scenarios where a owner that has put in most of the capital and sweat into companies then find themselves not being able to enforce shareholders' agreements that they've entered into because the structures, the traditional structures in the region do not reflect the deal that they originally thought they signed up to. And the second thing that I do want to emphasize is that RAK ICC is not to be used just for investments in the UAE. It really, and we'll elaborate on this a little later, but it is, a useful tool for investment just in the wider Gulf region. So moving on then to the benefits of a RAK ICC vehicle, as Nabil alluded to, there is freedom of contract and there is freedom to write in the articles exactly what you have agreed with the other shareholders. There's a much lower cost of formation as well, because again, in traditional LLC structures, and even in some free zones, it is a requirement for a new entity to have actual physical office space. And a lot of the time in that vehicle is only a SPV, that office space is a complete waste. Time for formation. It is not unusual for LLCs in this region to take several months to form, whereas a RAK ICC can be formed in just a few days, assuming all of these documents are ready. There are no corporate taxes, capital gains taxes, withholding taxes, and stamp duty on the transfer of shares in RAK ICC. The RAK ICC has entered into MOUs with the DIFC and ADGM courts. So ADGM and DIFC courts and arbitration is available. Goes without saying that there is no foreign ownership restriction in the RAK ICC. And finally, and most importantly, authorities in the other Gulf countries, the entities that are formed in the UAE, including in RAK ICC, to the GCC entities. And this has important implications because there are certain benefits that are conferred on entities in the region as opposed to other offshore jurisdictions such as Mauritius, CBI, and Cayman. So, for example, just as an example, if a Saudi partner is holding shares through a RAK ICC entity, that Saudi partner will be taxed, or that entity can be taxed as if the RAK ICC entity was a Saudi tax resident. And this is not possible for entities that are formed in the more traditional offshore jurisdictions such as Cayman and BVI. So we can move on to the next slide. We'll give you some live examples.
Yeah, so, yeah, Dora, thank you. So we're going to walk through, as Dora said, hey, look, we've now had a high level discussion of what does that mean? Okay, you know, we keep hearing about all these advantages. Is this any different than a typical free zone? And as Dora pointed out, yes, it is. So we thought, let's walk you through a couple of different examples. So for example, we all know that in the United Arab Emirates, there is the 5149 rule for onshore LLCs. As I mentioned earlier, there are lots of examples where the Emirati partner says, look, I understand that's a local law rule, but I'm going to put in, for example, 18% of the money, not 51%. And I agree in writing that I'm going to get 18% of the profit. Normally, that's of limited enforceability, depending on what you can get into the registered articles association, etc. So walking through this example very quickly, we could set up, for example, a holding entity in RAK, just to throw up easy numbers, have the UAE national owning 99% of that entity, the foreign partner owning 1%. Let's just say again that the UAE partner says, look, I'm really entitled to 18% of the overall profit. So we can have a shareholders agreement where we say, look, foreign investors are going to have Class A shares voting. UAE partner has Class B that can vote on certain things and not on other things. So they can always enforce their right to the 18%, but certain other things they would stay out of, like a typical minority investor in any other jurisdiction where they would negotiate typical reserved matters for a minority, even though the onshore company may technically consider them to be the majority. We can build in the appropriate protections for them as a minority while giving the foreign party the comfort that they're going to get the real benefit of the negotiated deal. We can have restrictions on transfers at the RAK level. We can make it easy transfer. And again, we can have the provisions that we would want, the tag, the drag, the dilution, etc. I think all of us now know too many challenging stories of parties doing this on the side, the so-called side agreements. And then what we've been seeing as a law firm, at least, is the foreign partner, even after a 15-year relationship with XYZ, goes to sell to a private equity group. And the person says, I own 51%. They go, no, you know that you really own 18%, not 51%. So you're going to get 18% of the profit of the sale. Go, well, that's some side agreement. And they have a very nasty court battle. And we've seen too many private equity groups then walk away, so that entire deal is lost. This creates a mechanism where everyone, including on exit, is comfortable of what is the real deal. I'm replacing you, foreign partner. I'm entering to a deal with your UAE national partner. How do I get comfortable that I have enforceable rights? And I think most people can get comfortable with an English law document. Let's go to the next one real quick. Laura, you have to tell us we're running out of time. So giving Saudi Arabia as an example, as others have mentioned, this is also where it gets very exciting, where we talk about, you know, in all honesty, a lot of parties come to us and say, look, I would love to make a mega investment in Saudi Arabia or Kuwait or elsewhere. I can't put in that level of money to pursue these opportunities when I've consulted with a local law lawyer and they've told me your tag, drag, dilution, put, call, none of that's enforceable. You can't have different classes of shares. You can give a shareholder a loan, but you can't perfect a pledge over that loan. They go, okay, I'm willing to make small investments in places like Saudi Arabia and Kuwait and so forth, but I can't make a large investment and have that at risk unless, you know, there's a government guarantee, etc. So the RAK ICC becomes a game changer. Why is that? For all the reasons outlined by Dora earlier. Look, number one, it's very low cost to set up the entity. And I know RAK is constantly benchmarking against the BVI and others to make sure they are providing the most competitive price possible to set up an entity there. As Dora said, it's not like setting up in the Cayman Islands or BVI, because let's just say, for example, your partner is a Saudi national, and let's just say, for argument's sake, it's a 50-50 joint venture. You say Saudi party, you're going to own 50%, company from US, Europe, India, Egypt, wherever they're coming from, Asia, you're going to own 50%. Great. Now in RAK, we're going to be on an even playing field. We're going to have an English law agreement. We can either have Class A, Class B, same class, whatever it may be. But now I can have my English law agreement where I can make sure all of that's enforceable. Now, the Saudi partner may very well tell you, you must be kidding. Why should I be dragged out of my country and have to be enter into a joint venture in RAK? I'm going to have to pay more taxes. This doesn't make any sense. I don't see the benefit of this. Why should I be negatively impacted? The point is this: 99% of the time what we find is that we will able to negotiate an agreement between whether we're on the Saudi side of the angle or the foreign partner representing the Kuwaiti, whatever it may be, and we will negotiate a very complicated joint venture agreement, but it's sort of a wink, wink. We know you can't enforce it in my country. The wink, wink disappears. We say, look, by having the joint venture under English law in RAK ICC, now we all have the benefit of that agreement. We're protecting the Saudi party in this example and the foreign party. They're getting exactly whatever they've agreed to. Now, again, the Saudi party may say, well, I'm going to now have to pay extra taxes. As Dora mentioned, there's now a double tax treaty between the United Arab Emirates and Saudi, where you can say, look, we can deem the RAK entity a Saudi Arabian tax resident. What does that mean? What that means is that that entity would file taxes as though it's sitting in Saudi Arabia, but we would get the benefit of the English law agreement in RAK and the ability to use the English law tribunals or common law tribunals in the DIFC and ADGM to enforce our agreement. So when money flows from Saudi Arabia to RAK, it's going to look at the fact that it's a GCC entity. So all the money essentially would flow from the Saudi Arabian entity to the RAK ICC entity. It's now a Saudi Arabian tax resident, remember. We would file with the Saudi tax authorities and they would say, okay, Saudi Arabian partner, you're going to pay zakat, which is 2.5%. Foreign partner, you're a foreigner. Just like when you were, if you came in directly in Saudi, you're going to pay 20% tax on profits, plus a 5% withholding tax on any dividends. The Saudi partner, in other words, is in the exact same tax position as if he was in Saudi Arabia directly. So no disadvantage for the Saudi party. The foreign party is in the exact same tax position as they would have been. And so we were dealing recently with a French client when they were looking at this thing, oh, they're not comfortable with the UAE entity because they view it as a tax haven. I said, look, we're going to deem this RAK entity a Saudi Arabian tax resident. So it's going to have paid the exact same taxes as if you came directly into Saudi Arabia. So you won't have this issue with your regulators in France. And they were, they went back, showed them that, they were very excited and got it approved very quickly. On the financing level, again, just to that last example very quickly, is when we try to go to a foreign bank and say, hey, please lend us money in Saudi Arabia, again, they laugh and say, how am I going to get security? Are you sure we can lend at that level? Can you pledge the shares? Do I have to appoint a trustee? And you end up with, 10 documents, sort of, holding, trying to scratch your ear like that, trying to create an enforceable position where the bank takes one share in the Saudi LLC to try to enforce certain rights, but they're not comfortable being a shareholder because of certain issues, et cetera, et cetera. So by lending at the RAK level, they're able to get the pledge of shares, the irrevocable power of attorney, the step-in rights that makes them comfortable. So for larger projects, for venture capital projects, for everything we were talking about, all the opportunities, it creates an even playing field for the bank, for the foreign partner and the local partner. And this again can be repeated in Kuwait, Oman, and so forth. Maybe we can jump to the next slide. Dora.
Yeah, so I'm just going to, very quickly go through two of the other uses. So one is, typically the Dubai Land Department will not allow Dubai real estate to be held by a corporate entity unless that corporate entity is, either a local LLC, an onshore LLC, or it's one of the registrars that have entered into an MOU. RAK ICC have entered into an MOU, so you can use a RAK ICC entity to hold Dubai real estate. Next slide. So what a lot of people are not aware of is that, the country is made out of 80% expats, and, assets that any expat has in the country, companies, land, etc., after they pass is subject to the local inheritance laws, which are based on Sharia, and which, will result in, for example, their sons inheriting more than their daughters, for example. And we've spoken to Sharia scholars, and we do believe that by pushing it into a foundation, which is, an internationally accepted vehicle for succession planning, you are able to pass on assets in the way that, a founder, a patriarch, a matriarch, etc., desires. So happy to talk more about the foundation, but I'm conscious of time, and we'll move now to the next slide.
I think that's about it. Yes, and then we could turn to Atiq's presentation.
Thank you, Dora and Nabil. It was very informative. But before we move to Atiq, just to remind you, if you have any questions, please type them now, and we will answer them at the end of the webinar. Atiq, over to you, please.
Thank you, Dr. Samir. Thank you, Lara, for having me. And I guess Nabil and Dora have nicely covered the technical and the parts of the holding company structuring. I'm going to touch on what goes behind when you are actually designing a holding structure, what kind of things you need to consider before you actually do the structure itself. This is just a definition as per the Commercial Companies Act of is concerned. A joint stock company or a limited liability company that establishes subsidiaries inside the UAE or abroad, or has control on existing companies by holding shares or stocks, enabling such company to control the management of the subsidiary and to have influence on decision of the company of the subsidiary. So this is technically a definition for what is called a holding company. But here you can see that even apart from ownership, the control plays a crucial role in qualifying it as a holding company. Of course, apart from the definition, holding companies are used for various purposes, and I will just go through them one by one. When you are actually designing a structure for a holding company, you need to keep in mind various things. First of all, what is the purpose? Why are you creating a holding structure? Holding structure generally would have multiple companies which are part of that holding structure. And that's how it comes as a layer by layer approach. Now, the purpose of holding a company could be different, and we need to understand whether it is for what reason, whether it's consolidation, tax benefit, controls, or host of a reason. And only when that purpose is properly understood, the structure, a proper and feasible structure can be designed. The stakeholders, of course, would have a vision with respect to what they want this group or a structure to go to. So that we need to consider what is the future vision of the stakeholders and what is the future plans, whether they want to diversify into different activities, whether they want to diversify into different jurisdictions, because each jurisdiction which has its own set of regulations and laws with respect to legal as well as tax structures, and whether there is any plant of any disinvestment or is there any plant to take into the structure of family kind of affair. So that has to be the future vision is also extremely important to understand before you actually take care of this. Jurisdiction, again, an extremely important aspect of where the holding company should sit. The choice of jurisdiction in which the holding company will be based is so crucial. Here, we need to evaluate the pros and cons. What are the risks attached in that particular jurisdiction and how can it be addressed? Generally speaking, if you see, when you are selecting a parent company for a holding structure, jurisdiction which is tax favorable is more or less the choice of design. Though that is not all. You need to consider other factors like the cost of operating that structure, the compliance burden, whether it is flexible and easy to operate. Even the reputation of that jurisdiction also matters. You could have a structure in an offshore jurisdiction which could be tainted, and that will affect your reputation as a company as so. So all of that has to be considered before a decision on what jurisdiction should go for will be arrived. So here we also need to see whether there is a possibility of migrating the whole structure in the future to any other jurisdiction. So that flexibility also should be offered. RAK ICC is one of the preferred choice because apart from migration, there is several classes of share offered and there's a lot of flexibility, and even the cost wise it is quite attractive. The other aspect you would look at is what kind of impact is there with respect to regulation and taxes. Stakeholders normally would have to consider the tax implicator and other owners of regulations and compliance before actually the whole structure is made. At times, tax burden might be less or not that large, but the regulation or the compliance part will be huge. So that also has to be weighed accordingly before you design or what kind of structure is there. Then we go into ownership. The ownership of the stakeholders, both current and future, has to be taken into consideration. When I say future, there will be a structure, you have a set of owners or one owner at the point of time, but eventually you should consider that again it ties up to the future vision, that if you are saying that there has to be another family members which are going to go into the group, or there is a likely disinvestment, then those kind of factors would have to be considered. So you structure it in the right manner that it is easy to maintain as well as easy to silver. The management part, the stakeholders would have to look at what is the outlook on the compliance, what kind of management they are there. So here, what is the influence, the overall structure, and hence the culture of the management also is to key. If you're looking at, the culture-wise, you might end up in designing a different kind of structure for this part of the world ownership, and it could be a different structure for a Western kind of a country. So the culture of management also is very important when you take care of the structure. And again, each structure will have to consider the risk appetite. Risk appetite would mean that the stakeholders and the management have normally different kind of risk appetites. Some would be more going forward to take a risk, others might be more cautious. So before you design, we need to align that risk appetite to ensure that this kind of matters are properly addressed. Of course, as I mentioned earlier, RAK ICC is one of the preferred destinations for structuring is done both at the level of the parent company as well as layers below. Can you move to the next slide? Okay. The structure basically should facilitate both the current and the future needs of the stakeholders. So when we are talking about the structure itself, what are the attributes or what kind of models can be there. I'll just explain that further. Normally when we design, it should be, the structure should be able to take segregation on with respect to sectors. So when I say sector-wise segregation, it means that business may be diverse, not only with respect to the activity, they might be having several activities. Let's say they might be automobiles, they might also be into textiles, they might be into manufacturing, trading, consulting, different kind of activities could be there. That aspect has to be considered. Also, we need to consider whether they are in one jurisdiction at point of time or they are into multiple jurisdiction, and whether there are any plans for further diversifying to other jurisdictions. So the model should be in a way that this the structuring should be in a way that it gives sector-wise bifurcation or segregation. Then, of course, we have to take care of the risk and how to mitigate it. That is always, as an advisor, we would identify the risk and provide solution or solutions in the risk mitigation of any given structure or multiple options of structures. At times, it will be necessary to add more layers just to ensure that the risk is properly addressed. Sometimes, like we had a client who would very cautious on the risk, and he didn't want each entity to be related to the other. So we designed it accordingly that it would be independent entities, yet it could be somehow tied with through an agreement. So this is how we can take care of that. Then when you are doing a structuring, we need to also take care of the, because if you would have multiple verticals, and in case of a disinvestment or another going for an IPO, it is quite necessary that you could either disinvest one or all of it. So the structure itself should be good enough to take care of that. It should be flexible, that if even one arm or multiple arms of it are disinvested or goes into IPO, it would not disturb the rest of the structure. Management control is also one of the key things. The structure should provide a proper control, which to ensure that the proper management control can be exercised at each level. Apart from that, it should be flexible to delete management or add more functions as per need, because the structure itself will keep on changing if new people or new investors join in, and it should be the management control should be flexible enough to take care of that issue. And of course, consolidation is one of the key factors which is required not only an aspect of control, but also with respect to funding. So the structure should be robust and compatible, so it both legally and from accounting standards, to ensure that the proper consolidation as desired can be achieved. Apart from that, this structure should offer asset protection as desired, and it should take into consider transfer one or part or disposal of an asset as required. And my colleague, other speaker has already, we just touched upon succession planning. It should also take care of the succession in an easy way. Now, this is a case study on actual practical example of how structuring of a holding company can take place with the offshore structure. So let's say there are three main owners or shareholders. They could have a holding company structure within an RAK ICC. And then you could have different verticals, and each of these vertical could be representing a different arm of the business. Let's say offshore, marine, consulting, contracting, and each of four of them could be a subsidiary to the whole group. That is one layer added. After that, if there are further layers, it will be as per that vertical. So you keep on adding verticals. So it is within the same kind of business line. And if there is a need, it can be severed for a disinvestment if desired. This is a practical example of what we have done for one of the group companies. I guess that's it from my end, if I'm open.
Thank you, Atiq. Okay, we'll go ahead and take some questions. We have few questions from the attendees. There is one about if the RAK ICC owner is not a UAE national, can the RAK ICC entity still effectively access UAE tax conventions with countries such as the UK, Canada, etc.? Matik, would you like to answer, or Nabil, this question?
I will leave it to Nabil.
No, thank you. So, in general, yes, we have lots of examples of RAK ICC entities that are 100% foreign owned, being deemed tax residents and able to take advantage of the tax treaties. It's not, there's no requirement that it's owned by Emiratis to meet most tax treaties.
Okay, thank you, Nabil. What's the specific difference between an offshore company with RAK ICC and other UAE free zone offering similar entity type? Dr. Samir, would you like to answer this question, or do you want to?
my answer would my answer would of course be very geared and skewed to a RAK ICC, because I think what I said earlier on, it's customer service, cost and ease of doing business, etc., etc. So I know we have a cost advantage. I know we have a service advantage. I know the rules and regulations are pretty similar, but we've added some features that have been mentioned in the presentation so far. And that is why our numbers keep going up, and whereas the competition goes down. It's demand and supply, and the demand is coming to us because of all the things that we've talked about.
I'm going to embarrass Dr. Samir and Laura briefly, just saying that, look, while Dr. Samir threw out that term, sort of personal touch and service, I can't emphasize how true we're seeing it also as a law firm and a service provider. In terms of some of the other zones, they are telling us, look, we reach out to them and we say we need to set up a local bank account, and they go, that's not our problem. Oh, we need to do X, Y, Z, or can we meet, or this doesn't make any sense to us. I've been amazed and impressed that someone, that folks like, Dr. Samir, again, former CEO of some of the leading companies, Laura, a superstar in Intertrust, are willing to sit down face-to-face, people drive from RAK and meet with people in Dubai on a regular basis to make sure they're comfortable, answer their questions, and be very proactive in helping them find solutions. I haven't seen it in any jurisdiction.
Thank you so much. Really, thank you. And there's another question. Am I right in knowing that no UAE resident visa is allowed for offshore companies? Yes, however, as Dr. Samir mentioned, there are some options available at RAK ICC. We have what we call the premium product, whereby you create a subsidiary with our sister organization RAKES, and you can apply for a residence visa and avail the double taxation treaties. There's another question about, is there any possibility that the RAK ICC, which is 100% held by UAE nationals, sorry, one second, to be used as a corporate shareholder or local service agent in UAE mainland companies? Maybe Atik would...
Yeah, I can take that. In fact, yes, this is quite possible. You could have RAK ICC 100% owned by UAE national to act as a 51% shareholder in the LLC company in the main UAE LLC. Given the practical aspect of it, every year you would have to provide that the shareholding remains the same when you are renewing the license. So yes, it is definitely possible.
All right, thank you. I think we've covered all of our questions. No, there's one more. Given the regulations for digital crypto asset in the UAE within other financial free zones, can a RAK ICC holdco be used to dilute a shareholder's holding with an STO to be traded in the future? Maybe it's a combined answer between Dr. Samir and Dora.
Well, all I can say at this point is that it is an area that is definitely of interest to us, and we are doing quite a bit of homework to see if we can offer more solutions for blockchain, crypto, etc. Of course, the UAE has regulations on this, and so we want to be within those regulations, but we've got the offshore side of the equation and want to offer flexibility, but also to be within the law. So I don't have a full answer to that question, but it's something that we're looking at very closely.
Okay, I think one more coming. How do you fulfill the Saudi Ministry of Investment requirements, 1 year audited financial, etc., when you have a new RAK ICC company holding shares in a Saudi company?
Excellent question. And you're absolutely right that the Ministry of Investment of Saudi Arabia, which regulates all foreign investment into Saudi Arabia, has a standard rule that says the entity should have 1 year of not only financial statement, but positive financial statements. However, what we've seen over and over and over again is they have great confidence in RAK ICC and certain other of the financial free zones in the UAE. And when we go and show them the entity is, has, for example, a 3-year history in France, and we set up a brand new entity in RAK ICC, it will tell us, they told 100% of the time so far, show us the financials from the entity in France. More recently, in the venture capital space, where we had a bit of back and forth with them, where a new entity was set up. It tried to set up in Saudi Arabia. They were denied, and they said, the financials are very poor. And we said, look, it's a startup company. It's emerging. It's based in a new financial free zone, but it's not because it's a new financial free zone. It's a startup company. And by the way, it happens to be on the cover of Forbes this week. And so they said, oh, oops, we'll approve that immediately.
Yeah.
Okay, thank you. Regarding holding of freehold properties, is it limited to Dubai freehold? The answer is yes. Okay. I think we've covered all our questions, and we are on time, actually. I would like to ask the panelists if there's anything else you wanted to cover before we wrap up.
Lara, I would just like to thank Nabil, Dora, and Atiq for the excellent contribution and very informative and clear contribution. I think this is one of the best webinars that we have hosted. I really thank you all for your contribution. It's been extremely useful. I hope all the panelists, the participants that joined us found it useful. And personally, I'm left with a number. I actually took a lot of notes. I think we should definitely get together and explore how we can do a lot more together, because definitely the demand is there and the focus on the region is growing. And I think there is a big opportunity for all of us. So again, Lara and everybody, thank you very much for joining us.
The only file
thank you.
Is just to echo that, is that we're actually seeing a number of parties wanting to now re-domicile to the RAK ICC because of they're finding out all of the advantages at the lower cost and the personal touch. So thank you all for your hard work.
I would like to also add that, around the globe, if you're talking about offshore jurisdictions, it's more and more regulated now. And that plus the cost of maintaining that is becoming quite extensive. So that way, being in the GCC here in RAK ICC is one of the very cost effective. And that's a really good aspect about it. Thank you, Dr. Samir.
Great. I would like to thank our esteemed panelists for their valuable contribution and informative session. I would also like to thank everyone for joining us today, and hopefully we'll see you next time. Stay
safe, everyone.
Thank you.
Bye.
Thank you, Steve. Bye-bye.
Bye-bye.